All right. I didn't know if I was quite ready yet, but I had to come in here and interject what I was seeing in the chat here. There is some absolute anarchy going on here. Actually, that's probably not the right word for it, but Bruce, stop using the word moist, please. It's like overuse. It's like he knows that it bothers me. But okay, I love him anyways. Mm. But what really got me is when he made fun of Perkins. Perkins is a treasure. Okay, I love Perkins. Perkins is like full of old people and pie. And after a long week of practices in college, I used to go down to the Perkins um near where I lived at the time, and I would sit in there and I'd eat chocolate chip pancakes and just like soak in the silence around all the old people who are just like playing their crosswords or whatever. It was like very peaceful, very peaceful. We like Perkins here, sir. Hey, Winks, what's up? All right. Well, Bruce's creep game is so on fleek. Laura Owens stopped trolling him on YouTube. What? Well, she can stop, but I'll never stop trolling Bruce on YouTube. Um, Bruce, we should just have a roast one night. I know what we could do. We could do a Bruce roast for charity or something. It'd be awesome. Capital Callout says, okay, guys, this is not starting how I thought it would. Capital Callout says, I'd rather read moist than seepage. Why would you say that? Now I'm not going to be able to stop thinking about it. Oh, Winks, I'm so sorry they took your Perkins away. That's just tragedy. Um, guys, I saw this earlier, and I saw I'm working today from home, and I get an hour break every day, so I had to wait until I read this. But just to point out, before I start reading the actual document, his Twitter account today, like he can't help but like put a little jab in there, right? And hold on, let me make sure you guys can see the whole thing first. No, because my head's in the way. Here we go. Nope, that didn't do it. My head's definitely in the way now. There we go. That's better. That looks stupid though. Hang on. No, no, no. I'm still playing with this thing, guys. Okay, so you guys can see it now. It says this is on ECR, which I'm assuming means electronic case record. And only one person asked for a copy. But just in case you don't have a job, and the only way you can make money is by sitting and reading someone else's work on YouTube while slamming them and boasting about what a genius you are, a gift. David Chingris, the true philanthropist, everybody. Um, well, I work two jobs in healthcare. Neither one of them is YouTube. And I just recently started doing this because I like it and it's fun. But since I do have two jobs, I will go ahead and read this and not feel bad about it. Because apparently it only matters if you don't have one for him. Um, Not to mention, and I've said this before, I'll say it again. Like when people rag on like YouTubers or content creators, and I'm not talking about people who like just post pics of themselves places and advertise for Fit Tea, right? I'm talking about like Dave who reports on stuff and like does a lot of work to do his podcast and all that. Like he puts a lot of work into it. If you don't believe me, then like go watch Work with Dave, right? Because it can be a little bare bones and frustrating sometimes for him, and he has to like go and look for things that we want to hear. And yeah, I don't know. That's just one of many reasons why I'm sure that's difficult. But um, yeah. So like when people say stuff like that, and they're like, YouTubers are just like scum working for like scraps and like grifting and all that stuff. I'm like, no, dude. Like YouTubers, they work like all of us, and they also pay taxes like all of us. So why don't you chill the fuck out? So if you could like make your points without saying stupid shit like this, then maybe your rate would go up, sir. Hey, Green Kids Taxi, what's up? All right, that being said, that's enough of this man's Twitter account for one lifetime, but I'm sure we'll be back to it at someday. Maybe I should unblock him. You know what? Let's do a poll. Hang on. Sorry, guys. Hang on. Let me mute the microphone so you don't have to listen to thunder keys. All right, there you go. Should I unblock David on Twitter? Yes, no, or who are you? You guys vote. It's in the poll in the chat right now. So, um, Brad thinks Thunder Keys is funny. That's awesome. Guys, speaking of, I will be streaming tonight. I believe my cousin will be joining me. She is a PhD in French history. She just got her PhD, and we'll be talking to her about some stuff. And then also, so I've been telling her about this case, and she has not really been following it closely. So what we're gonna do is I'm gonna break out some of the weirder stuff that's happened in this case, and I'm gonna have her react to it for the first time. I might even do a little bit of a two truths and a lie and see if she can figure out which is made up. Like, I'll put two of the more bizarre things that she said and then like one lie and see if she can get it. So yeah, maybe if Bruce and Brad aren't too busy, they can join us, but we'll see. I'll message them later. As long as Bruce doesn't keep saying moist. Jermaine down. Is that Teams I hear in the background? Yes, it is. So I work from home during the week, and I am going to use my lunch break to do this. So I get an hour break every day, or like, so you can either do the hour or you can do a 30 minutes into 15 minutes throughout the day. But I get to pick and choose when I do that. So yes, you're hearing notifications in the background. That's our group chat. I'm on a team like within the office, like online office. So yeah. Okay, Bruce, I'm not gonna read this out loud, but I'm like really mesmerized by your way with words. This is amazing. I want you to write a book of poetry. Brad says, "How can you find two things she didn't lie about?" I don't have to. So like the thing is, like, we won't tell her, but like I'll pick two like bizarre things and I'll like lie and make up a third thing, and she has to like decide which one of the things is a lie. And I know she's not watching this right now because she's working and she doesn't get to watch a lot of streams, but so yeah, we'll make up something. Like, so we'll have, say we had like the tight vagina email thing, right? And then the Clayton invited me to his apartment was fraud thing, and then I make up a third thing, and then she has to like figure out which one was made up because she's never read any of this stuff. So yeah, it'll be interesting. All right. Let's get into it. So this is the response slash objection to the application for attorney's fees and costs. As you guys know, a little while back now, Clayton filed his request for fees, and it had like all this stuff listed, and we kind of went through that, and there was some eye-opening stuff in there. But reminder that like a lot of the stuff was billed to Isabel, not Greg, so that would keep the cost down a little bit. And that's going to be relevant later on here. Okay. This case is currently in a difficult and unfortunate posture. As a result, this brief is almost certainly futile because no matter what is argued herein, Clayton has either already won the issue or he has already lost. We just don't know which it is yet. Well, I mean, we kind of do, but sure, man. As the docket reflects, as of today's date, there are two other pending unresolved matters. A, Laura's notice of change of judge for cause, filed July 8th, and B, Laura's motion for new trial and other relief, filed July 12th. Both filings raise the same central issue, misconduct by the trial judge, which violated Laura's right to a fair hearing. Based on that issue, among others, Laura has asked for an order disqualifying the currently assigned judge and ordering a new trial. These requests are essentially overlapping. If the disqualification request is granted, a new trial is probably automatic. thereby mooting the current fee application. I don't usually hear people use mooting like that, but I think I'm going to start doing it. Okay. On the other hand, if the disqualification request is denied, the outcome of Clayton's fee application is a foregone conclusion. Due to this unusual posture, this brief is unlikely to have any effect on the outcome of the litigation, except to the extent any of the issues may need to be raised later on appeal. Accordingly, this brief will present Laura's arguments in an abbreviated manner, solely to ensure non-waiver on appeal. So, normally I would make fun of them for saying abbreviated manner because, you know, they actually are kind of long-winded in these things. And I will say, like, it's not the most abbreviated it could be, but it is relatively, you know, concise compared to some of the other things we've seen. And, like, a lot of this stuff goes on after the end of this part of the document. So it's like, I think there were like some graphs or something in there. I'm not sure. I skimmed it, but I'll look at the end for you guys. Capital call out says it's like a cow's opinion. It's moo. All right. So a couple things came to mind when I was reading this. So, when we're talking about the misconduct by trial judge here and the, you know, I'm thinking about his filings, the filings he's noted here. And I'm thinking about how disrespectful he was in a court filing to Judge Mata and how he's been with Greg, which you'll see a little more of in this filing, actually, with Greg Woodnick and Isabel and Deandra. And I'm just thinking about that. And then you go back to that tweet from before. And think about that. Like, he's mad that people sit here and read this stuff and like are dunking on him basically and like saying negative things. And I don't know who's boasting about what a genius they are. I can tell you that I've sat here a bunch of times and I've been very candid where I say, like, there's stuff I don't know, and if I don't know it, I will tell you I don't know everything. So, you know, I try to be upfront about that. And I try not to speculate on things I have absolutely no idea about. So I don't know, you know. I don't know who he's talking about there. I don't think Dave sits there and talks about what a genius he is. I definitely don't think Megan does. I don't think Tug does. I know Omar doesn't. But yeah. Actually, I know Dave and Megan haven't really done that either. At least unless it was in jest. That's not really a thing. So, like, I keep these things in mind when I'm reading these documents, and I'm just kind of like, dude, like, you can't just pretend that stuff didn't happen and then talk like you're some kind of victim. It's ridiculous. Hey guys, if you came in here a little bit late, we're reading the response objection to the fee request. So we just got into the beginning of it. You haven't really missed much. Hold on, let me see what the poll results are. Okay. Let's look at this poll. We have yes, 42%, no, 46%, and 12% say, who are you? Guys, again, if you were late coming in here, I have a poll up there. It says, should I unblock David on Twitter? I'm going to leave that open for a little bit longer because it's very close. It's very close in the poll. All right. Now we get into the discussion. While considering the issue of fees, it's important to stop and note the context. This case involved a petition to establish paternity filed pursuant to this rule. That's what I'm going to say from now on whenever I see a long number or whatever. This rule. Especially if I see fucking Rule 26 one more time. Which I'm afraid I'm going to. When such a petition is filed, there are only two possible outcomes. Paternity is established or paternity is not established. Although the parties vigorously dispute the question of whether Laura was ever actually pregnant, two key facts are entirely undisputed. One, both Laura and Clayton were pro se from the day this action was commenced on August 1st until mid-December. And two, Laura moved to dismiss this case with prejudice on December 28th, 2023. This timeline is crucial to understanding the fee issue, so the relevant dates are depicted in the diagram below for clarity. Point A, petition is filed 8/1/2023. Point B, Woodnick appears on 12/12/2023. Point C, Laura moves to dismiss on 12/28/2023. And point D is trial on 6/10/2024. So I guess this is like an interesting little like version of the MCU timeline that he's doing here, since he's such a super brain. Hold on. As this diagram shows, it is an undisputed fact that between point A, commencement of the action on August 1st, and point B, when Clayton's counsel first appeared on December 12th, neither party incurred any legal fees because both parties were pro se. Despite this, Clayton's fee application shows substantially all fees he is seeking were incurred between points C and D, which, as explained below, was completely unnecessary as a matter of law. Oh, God, this again. So I'm sure you guys noticed this, but there's a lot of stuff missing between these points on the timeline. So that's a little questionable. But okay. Joe Law, I kind of want to know why you blocked him. Well, because he was posting like it was what finally like did it for me was he posted that picture of Mike and the podcast that Laura and Mike did, and it was just like, why are you humiliating someone who was put through hell by your client? And so I was just like, I don't want to see this anymore. So I just blocked him. And so now if somebody were to tell me like, oh, like he posted a filing or whatever on his page, I'll go and I'll look at it, or they'll send it to me. Fine. But I'm not tempted to like interact or like rage at the guy, right? Because I can't. I have blocked him. So I don't think any good would come from me arguing with him in a public forum or privately for that matter. There's really no point, I have really avoided criticizing him like as far as his personal life goes, his appearance or whatever. So when people make fun of that stuff, I think I did like one time slip a little bit and like I made a joke about some shorts he was wearing or something, but it was like just a joke about the shorts. The shorts were fine, you know what I mean? Like and that was something that was floating around on Twitter. I didn't like go out of my way to see like what's this man wearing today? Like he probably does with Dave. But Okay. Also undisputed are two other key facts. First, prior to filing a motion for leave to amend on December 12th, Clayton's counsel, Greg Woodnick, violated Rule 9 of the Rules of Family Law Procedure. Mr. Woodnick violated Rule 9 by bringing a motion without making any attempt to meet and confer with Laura to determine her position. Okay, so we've seen how Laura operates when it comes to like mandatory meetings and stuff like that, or necessary meetings. Like, think back to Clayton wanting her to take the paternity test, and she refused to do it unless he met with her in person. And then it was, well, no, we have to meet in private. And like, she's claiming the guy, and I can't believe I have to start censoring myself so I don't get demonetized because it keeps happening. ARPed her. She's claiming the guy ARPed her. And she's like, I only want to meet in private. What the fuck is that? And then of course I go and I swear right after that. So like I'm hopeless, guys. It's okay, because like I said, I this is not my job, so we're good. Okay. But you think about stuff like that, and then it's like, were there attempts to meet and confer with her? Is it possible that she was being unreasonable? It seems likely. Don't tweet if you don't want to roast. Well, Bruce, I do want to roast, but like for dinner. So I'll tweet at you later. Okay. This leads to a second key fact. Immediately after Mr. Woodnick appeared, Laura's first step was to file a motion to dismiss with prejudice on December 28th. That fact has been largely, almost entirely ignored by Clayton's counsel and by the currently assigned trial judge. But as a matter of law, the dismissal motion terminated any right Clayton may otherwise have had to seek these after that date. Put differently, Clayton's present fee application seeks an award of $154,000 plus in fees and costs, incurred for the purpose of defeating Laura's petition to establish paternity by proving she was not pregnant. But Laura's motion to dismiss is unequivocally admitted that fact. The second line of the pleading stated, petitioner is not now pregnant with respondent's children. Motion to dismiss filed 12/28. So that fails to mention that she was never pregnant with his children. But okay. That's the important part, dude. She was never pregnant with his children. That's why this whole court case was so bonkers. All right. Viewed in that context and putting aside his counsel's violation of Rule 9C. So viewed in that context is important here. Viewed in the incorrect context. Okay. If Clayton was entitled to any fees at all, which he is not, the only time period involved would be between points B and C in the MCU timeline. From December 12th, when Mr. Woodnick first appeared, until December 28th, when Laura moved to dismiss. So from December 12th, when Thanos first entered Earth, whatever number, and then December 28th, when Thanos snapped his fingers and half the world disappeared. Or the universe, or whatever. Is that what we're saying? No fees may be awarded prior to point B, because Clayton had no fees prior to then, and no fees may be awarded after point C, because by that date, Laura withdrew her claims, or tried to. Dude, you don't get to just, like, crime all over the place and then be like, oh, sorry, never mind. We're good. And then think that you should never have to face any consequences. That's not how that works, dude. Of course, because Mr. Woodnick was required to meet and confer with Laura, if he had complied with that obligation, he would have learned by making a single phone call that Laura was no longer pregnant and that all paternity issues in the case were moot. So that was never really in question. I mean, I don't know that he would have learned anything. Of course, she wasn't then pregnant because she wasn't pregnant in the first place. But yeah, sure. This is kind of problematic, and like Mr. Woodnick was required to meet and confer with Laura, but your client has made some very interesting ex parte claims in another case with another victim who she did something basically identical to, by the way. She tried to send an ex parte email to the judge claiming that he was part of some sort of like creepy plot to have her assaulted. So like, dude, I wouldn't want to meet with her either. But I'm sure that, like, knowing how he operates, how Greg Woodnick operates compared to how David operates, I wouldn't be surprised if he actually did try to meet and confer with her. And if they just didn't like the way that, or they wanted, or if she just wanted something like less than professional, in like making that happen. So yeah, that wouldn't surprise me at all. So to recap, even assuming Laura was never pregnant at all, we're getting there. You're getting there. Even assuming Laura was never pregnant at all, it is undisputed Clayton did not incur any fees between points A and B. It is further undisputed that Clayton would not have incurred any fees after point B if his counsel had simply complied with Rule 9 by contacting Laura and asking for her position. And you lost the plot again. We were so close. Mr. Woodnick cannot and should not be rewarded for ignoring a mandatory procedure rule in this manner. Okay. BS says, wait, didn't the babies disappear? Well, it depends. What timeline are we using? Because this is like a multiverse, right? We had the timeline where she miscarried in, what was it, like July or summer or something? There was the timeline where she miscarried in September, October. There was the timeline where one twin absorbed the other. So yeah, it just depends on which of the multiverse timelines you want to go with, right? So there's just a lot going on here. Jermaine Down says she was claiming on/near Christmas that she was still pregnant. Correct. So that's one of the timelines. There's lots of timelines going on here. Okay. A. Clayton is not entitled to fees for litigating a moot claim. In her motion to dismiss, Laura explained she was no longer pregnant. and thus any paternity establishment issues were moot. It is well established that courts cannot decide moot cases. So he's quoting a different thing here. Hold on. That single fact precludes any award of fees incurred after December 28th because, as the Court of Appeals has repeatedly held, we are not a fountain of legal advice, and we will not decide a question which, by a changing condition of affairs, has become moot. Something tells me that decision that he's citing, it has nothing to do with the circumstances here, but okay, sure. Here it is undisputed. Laura admitted as of December 28th, she was no longer pregnant. Had Clayton's counsel complied with Rule 9, as he was mandated to do, Laura would have made that admission even earlier. Clearly, as a matter of law, Clayton is not entitled to recover $150,000 in fees for the purpose of proving that Laura was not pregnant when that issue was entirely mooted before those fees were ever incurred. Okay. All right, guys, it was a nail biter. It was a nail biter. Oh wait, we're still going. Okay, the poll is still going up and down. We're at no by 2%. So I guess I'll leave it open a little bit longer. B. Clayton is not entitled to any award of fees because his counsel violated Rule 9 and failed to provide the safe harbor required by Rule 26. Oh no, I knew this was coming. On May 10th, Laura filed a motion for judgment on the pleadings. In that motion, she argued Clayton was not entitled to sanctions as a matter of law because his counsel failed to comply with the procedural requirements of Rule 26. The motion further argued this error could not be fixed by the trial court sua sponte, converting the defective sanctions motion into one seeking relief on some other basis. I'm not reading this shit right here. I'm not reading that. Because I know it's just going to be the same thing that we've read over and over again, and it's just going to make me want to claw my hair out. So, not my eyes, but my hair. Here, the trial court simply ignored this rule and awarded fees to Clayton despite the fact it is undisputed that Clayton never provided Laura with the required written notice of her absolute right to withdraw her petition without consequence. In this way, the court deprived Laura of the safe harbor rights to which she was entitled under Rule 26. Similarly, the motion for judgment on the pleadings explained any other requests for fees/sanctions would be untimely because the alleged violation here was based on Laura's act of filing this case on August 1st without a sufficient factual basis. Allowing Clayton to incur $150,000 in fees between 6 months and nearly a year after that date is entirely inconsistent with the purpose of the rules permitting sanctions and/or fees for such conduct. C. Fees cannot be awarded for tort-based counterclaims. Screaming Rule 26 into the void. That's right, Claude. Alright. Fees cannot be awarded for tort-based counterclaims. The record in this case is clear. Laura learned she was no longer pregnant in mid-November, and after making that discovery, she filed nothing further in this case. Due to the lack of case activity on December 4th, court administration issued a notice placing this matter on the inactive calendar and stating the matter would be dismissed in early February if no further action was taken. Had no further action been taken, well, that's mooted, isn't it? Had no further action been taken, this case would have been dismissed without Clayton incurring a single penny of legal fees. Yeah, all he would have to do is sacrifice his reputation and his rights to have his name cleared, dude. Well, his rights to try to fight it in court, you know. Despite this, Clayton what, Lauren? What did you say? Okay. Despite this, Clayton opted to retain counsel for the purpose of amending his response to Laura's petition to affirmatively assert a claim that Laura was never pregnant at all in this case. Okay. As has been explained in other pleadings, the family court had no subject matter jurisdiction to decide non-paternity tort claims such as fraud, defamation, oh my god, I can't talk, or malicious prosecution, which is what Clayton's amended response to the petition effectively sought to raise. However, even if the court had jurisdiction over these tort issues, the court cannot award attorney's fees for Clayton's efforts to litigate those claims. This is so because Arizona law generally does not permit recovery of attorney's fees in intentional tort cases, including where such claims merely sound in tort. Okay. Here, Clayton's allegations against Laura sound in tort. They accuse her of committing fraud and other intentional torts. As such, even if the family court had jurisdiction to adjudicate such claims, which it does not, Clayton cannot recover fees under that rule for litigating those claims because the only claims remaining after mid-December were counterclaims that sounded in tort, not paternity claims arising under Title 25. D. Clayton has failed to show his fees were reasonable. Because Clayton is not entitled to an award of any fees at all, it is not necessary to determine whether the amount requested is reasonable. However, if that issue was considered, it is clear the fee sought by Clayton's counsel is not reasonable under the controlling standards of ER 1.5. That rule provides a lawyer shall not make an agreement for, charge, or collect an unreasonable fee. Okay. I'm skipping over some of this wordy stuff that's not going to tell us much. Well, I mean, it would, but it's not the stuff that you guys want to hear. To meet his burden, Clayton's counsel must show the fee requested is reasonable in light of the factors set forth in ER 1.5 as follows. 1. The time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. 2. The likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. 3. The fee customarily charged in the locality for similar legal services. 4. The amount involved and the results obtained. 5. The time limitations imposed by the client or by the circumstances. 6. The nature and length of the professional relationship with the client. 7. The experience, reputation, and ability of the lawyer or lawyers performing the services. And 8. The degree of risk assumed by the lawyer. Here, the affidavit of Clayton's lead counsel, Greg Woodnick, fails to mention, much less address, any of the controlling factors of ER 1.5. However, indirectly, on pages 3 to 4 of Mr. Woodnick's affidavit, he provides some background biographical information, which includes some volunteer work and teaching work. While certainly laudable, nothing in Mr. Woodnick's affidavit supports his claimed hourly rate of $650, which is nearly double the average and median rates for family law attorneys in Arizona, according to the State Bar of Arizona's most recent Economics of Law Practice Survey report, a copy of which is attached here too as Exhibit A. So here he's highlighted the family/juvenile average hourly billing rate, which is $329. This point is underscored by the fact that Mr. Woodnick's stated rate is indeed only $325, as listed in the attorney roster maintained on the Superior Court's website. Okay, so here's the attorney roster. There's Greg Woodnick, and then fees and services, it says family/divorce, and there's the $325 rate. To be sure, just because $329 an hour is the average rate for family law attorneys in Arizona, and just because Mr. Woodnick advertises his rate at $325 an hour, does not necessarily mean that $650 an hour would always be unreasonable for a lawyer with suitable experience, skills, and qualifications. However, nothing in Mr. Woodnick's affidavit supports the amount he requests, nor does he demonstrate that he is entitled to double his normal rate in this case. God, he has such a hate boner for this guy. It's crazy. Okay. Among other things, Mr. Woodnick makes no reference to any court ever finding that $650 an hour is a reasonable fee, given his specific experience, reputation, and ability. Indeed, Mr. Woodnick's affidavit makes no mention of any significant past litigation experience that would elevate his rate beyond an average amount. What? You're an asshole, man. Furthermore, independent research by the undersigned reveals that Mr. Woodnick's litigation experience in higher level cases is virtually non-existent. For instance, a diligent search reflects that despite his 20-plus years as an attorney, Mr. Woodnick has never participated in any matter resulting in even a single published or even unpublished legal ruling in any court anywhere in the United States, either at the trial or appellate levels. A search for Greg Woodnick in LexisNexis literally produces 0 results. Nothing. Okay, man. Wow. Okay. Here comes the bragging, guys. By comparison, during a career of similar duration, undersigned counsel, so David himself, has participated in hundreds of matters across the country, including numerous high-profile cases resulting in dozens upon dozens of published and unpublished rulings in state and federal trial courts and state and federal appellate courts. Oh my god. And then he's citing all those. To be sure, the existence or non-existence in Mr. Woodnick's case of substantial trial and appellate experience does not, standing alone, determine whether an attorney's fee is reasonable. However, the failure of counsel to demonstrate any basis for an hourly rate that is nearly double the average prevailing rate for family law attorneys in Phoenix is dispositive. The court cannot and should not find the fees requested by Clayton's counsel are reasonable, not because the fees are conclusively per se unreasonable, but rather because counsel has failed to meet his burden of showing the fee meets the requirements of ER 1.5. Wow. Okay. BS says this guy has high profile cases. This guy is a perfect fit for LO. That's definitely true. Dude, this is so crazy. Like, the chest beating on Twitter was bad enough, but here it's like, dude, stop. Auntie M says he's making us forget that there were always two people present when dealing with Laura after the FBI crap. For those of you who don't know, I think the FBI crap Auntie M is referring to is the ex parte email Laura tried to send the judge in Greg Gillespie's case, stating that Greg Gillespie and Greg Woodnick were part of some scheme to have Laura assaulted. So yeah, that's something we'll use in Two Truths and a Lie tonight with my cousin, probably. All right. The requested fees and costs were not necessary. Before any fees or costs may be awarded under ARS 25-809, the court must find those fees and costs were necessary to the outcome. Here, the post-trial minute entry does not contain any finding that any of Clayton's fees or costs were necessary, nor is there any basis for such a finding. Okay. As noted above, it is an undisputed fact that after learning she was no longer pregnant in mid-November, Laura filed nothing further in this matter, and she did nothing to keep the case alive. It is further undisputed that before Clayton's counsel appeared, the case was scheduled for administrative dismissal due to inactivity. Against that backdrop of undisputed facts, there is no good faith basis to argue that it was necessary for Clayton to incur any fees or costs in the defense of this action after the matter was placed on the dismissal calendar. To be sure, Clayton's desire to use this case for purposes of publicity and his counsel's wish for personal revenge against Laura may explain their efforts to keep this case alive as long as possible. However, those acts, which constitute actionable abuse of process under the Court of Appeals decision in Crackle versus Allstate Insurance, because that's the same, do not mean that any of the fees incurred were necessary to resolve the establishment petition filed by Laura. Because such fees and costs were not necessary, and because there has been no finding on that issue, Clayton is not entitled to any award of any fees or costs. Wowza. Okay, conclusion. For the reasons stated above, Clayton's application for fees and costs should be denied in its entirety. Signed, David S. Gingras. Jesus Christ. That right there is just like, the lack of self-awareness is amazing. Their efforts to keep this case alive as long as possible. Like, they're the ones doing all these unnecessary filings, and all these stunts. Now trying to appeal or get a new trial, making that weird statement about her right to a jury trial. Like, come on, man. You can't be serious. Desire to use this case for publicity. That's an interesting accusation because Laura Owens was the one who went to the press. Laura Owens used that to try to get Clayton to bend to her will. So that's ridiculous. Of course, like when she puts out all this bad publicity about him, he has a right to try to clear his name. His counsel's wish for personal revenge against Laura may explain their efforts to keep this case alive. So that's related to what we were just talking about earlier, the FBI thing, the ex parte filing. Like in that ex parte, not filing, but in that ex parte email that Laura Owens sent the judge, she claimed that the FBI was investigating this pretend assault scheme by Greg and Greg. So it's just so ridiculous. Motion to compel naps. What? Oh man. Guys, this is like down to the wire. We've been going back between yes and no. Now we're at no 46%, yes 44%. So we're leaning towards no, I think. I'm gonna give it another minute, but that's about it. Bruce from Oregon says she's a cookie full of arsenic. Ew. How's your rooster, Bruce? Jermaine Down says, I just looked up the attorney roster on the Maricopa court site. Seems David is using a dated version of Greg Woodnick's roster page that is no longer linked on the active roster. That is totally on track with what he's doing here. That's amazing. All right, let's see. What do we got here? Oh my god. We have yes 45%, no 45%. Okay. State Bar of Arizona Economics of Law Practice Survey Report. I think this exhibit is just like talking about the rate for lawyers. Yeah, this is talking about average base salary. Okay. And this is showing members responding have been licensed to practice law for an average of 20.2 years. Okay, and then it's showing the average annual base salary. Okay. 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 I think most of the rest of this document is this stuff. As of January 1st, 2022, what was your annual base salary in US dollars? Okay. So people with less than 5 years of license to practice law. Let's see, most of them said 75,000 to 100,000. 20 to 29, most of them said 100,000 to 150,000. 30 or more, most of them said, yeah, 100,000 to 150,000. Okay. The average for somebody with 20 to 29 is 171,465. I'm not going to read any more of these salary statistics because I don't think it's really that important. Yeah, the rest of this really is just this statistic stuff. So it's like page 10, right? Okay. He does have a pie chart. Pie, ew, not that kind of pie, dude. Auntie M, there's pie at Perkins. Remember, so you can go to Perkins. You don't need that. Gorilla BFF says unblock only to mess with. Well, I'm not trying to mess with them because then I would have to talk to him. And I'm not really trying to do that, so. All right. The poll has ended. We had yes 44, no 44, and who are you at 10%. So that's weird. When I pressed the end button, it said no 45, but that's fine. I'm not gonna do it because we don't have an overwhelming yes. So, oh well. I guess he's staying blocked. But I do have when he posts these things and somebody doesn't send it to me and they're just like, "Hey, this is on Twitter." I do have another Twitter account that I use and I go find it. So it's not really that big of a deal to block him on my other one. Class of 83, hey Rob, don't do it as he will claim you are stalking him online. I mean, he could claim that, but that's not true. Well, first of all, like, how would you even prove that? I read someone's tweets online. Like, that's not stalking. It's not stalking. Let's see. Jim Schuler says, so what is Gingris's average rate? Considering Woodnick spanked the pants off him, I'd wager Woodnick should be worth a higher fee rate. I don't know. I don't think we know what his rate is. Grandkids Taxi says, good, why open yourself up to his BS? Well, to be honest, I'm like, the BS is mostly getting to me anyways because people are always talking about it. So, and then, of course, this stuff. Hey, Erica, what's up? SG will find a way, just like with Dave Neal, just be aware. I don't know. I think that would be a waste of his time. But, you know, I don't anticipate that to happen. It would also be a really bad look for an internet lawyer who's fighting for people's freedom of speech. So, like, I don't think that that's going to happen. Yeah, that would just be frivolous. But thanks for looking out, Rob. I appreciate you. Tier Dad says, can the presiding judge get a move on, please, and issue a ruling? I would love that. I don't know how long that's going to take. Hopefully, we'll get that soon. Okay. Well, guys, I gotta get back to work. It's 2:56. Hold on. Give me 1 second. I think Brad's gonna be starting shortly. So I'll go ahead and... Give me 1 sec, guys. Yeah, there it is. Okay. Okay. Stephanie B, hi, what's up? Ginger Jim says, thanks for spending your lunch break with us. You're welcome, Ginger. It was my pleasure. Thanks for coming by. So Brad is about to do his dramatic reading, and that's where I'm going to redirect you guys. So I will be back tonight, like I said, with my cousin. She has never, like, really heard this stuff before, like, read the more ridiculous parts of this case before. We're going to go over that with her, see her reactions to it, and also we're going to do some kind of, like, two truths and a lie thing. I will have two things that Laura has actually said and done in this case, and then I'll make up a third thing that's either bizarre or actually makes more sense, and we'll see if she can figure out which one is the fake thing and which things actually happen. So that'll be fun. I'll see you guys tonight. Stephanie B, this was just a response to the thing involving attorney's fees. Okay, I'll see you guys later. As soon as I hit this end button, you're going to be redirected to my friend Brad. He'll be starting his thing in 2 minutes, so please let him know that I sent you and send him some love. Type lots of bacons in his chat. TM says, do you not like your cousin? My cousin's been my best friend forever, so no. So no, I hate her. All right, bye, guys. Bye, Rosalind.